The final case this morning is People versus Fontenot, also a 15-minute mini oral argument on the application. Ms. Sharon, you may reserve some of your time, and you may proceed.
Thank you. Good afternoon, Madam Chief Justice, and may it please the Court. Alona Sharon on behalf of the appellant Alton Fontenot, and I will attempt to reserve 3 minutes for rebuttal. Evidential. Evidential is an adjective defined as of or providing evidence. The logs that are the subject of the instant case are entitled Evidential Breath Testing Accuracy Check Log. Immediately under the document title, those who are responsible for entries into the logs are warned that failure to comply may result in breath alcohol analysis results being inadmissible in court or other proceedings. The administrative rule refers to the data master as an evidential breath alcohol test instrument. Before this court is the question of whether the certification that is placed in the logs that the machine has been inspected, serviced, is accurate, and is in proper working order is a testimonial statement. This honorable court must respectfully conclude that the certification is testimonial and does not qualify as a business record. First, the document itself acknowledges that it is meant to be used as evidence, not simply as record keeping. Not only does the title of the document reflect its evidentiary nature, but the warning contained immediately underneath the document title reflects reflects the anticipated need for the logs. That is, they are needed to be used in litigation. They are intended to be used in litigation, more specifically criminal prosecutions. Second, Michigan case law requires that in order for the results of the data master to be admissible in a drunk driving prosecution, the results must be reliable. The maintenance and certification of the machine proves its reliability and is done for the purpose of proving a past event, the reliability of the machine. For that reason, the certification is testimonial. It proves a past event relevant to a later criminal prosecution. Because the documents are on their face prepared and maintained for the purpose of providing evidence and for the purpose of assuring the admission of evidence at trial, the document cannot fall under the business record exception. The prosecution in this case relies heavily on the primary purpose test and the fact that because the certification takes place before there is an identified defendant or suspect, then the certification cannot be testimonial. But this argument respectfully ignores this honorable court's binding precedent and tries to hang its hat on a non-binding Supreme Court plurality opinion. And I use the term plurality loosely, just as Justice Kagan did in Williams versus Illinois. In 2011, this court issued its opinion in Appellant, in which the court very clearly said that the touchstone of whether or not a statement will trigger the confrontation clause is whether or not the declarant would reasonably expect that the statement would be used later in a criminal prosecution. When you look at this document and it tells you that it is an evidential log, and when it warns the person who places a certification on that log, almost with a finger wag, if you don't do this properly, this isn't going to come into court, it is impossible to say that the declarant isn't putting the certification on the log with the expectation that it is going to be used for a criminal prosecution at a later time. And for that reason, it falls under Appellant's definition that would trigger the confrontation clause.
Counsel, does it matter that in addition to that use, which clearly is important, there are probably other uses? Like, I assume the police want the machines calibrated correctly so they know that the person they have in custody is the right person, because if it's not the right person, they might want to let them go, right? So it seems to me that there's another reason why having the machines calibrated correctly is important, and doesn't that make a difference for the confrontation clause analysis? Well,
I think yes. I mean, number one, they don't want to detain someone who they shouldn't be detaining. But also, I mean, right, the data master is there for purposement of punishment. These logs are kept for the purpose of punishment and potential prosecution. And for that reason, I think it's critical that the confrontation clause is triggered. I'm not sure if that speaks directly to your question, Justice McCormick. But in terms of Williams versus Illinois, which this court and the Fontenot Court of Appeals opinion, I think, heavily relied on, it's incredibly problematic because as Justice Thomas joined 4 other justices in that opinion in recognizing that there is zero authority for this primary purpose test, that there has to be some identified defendant in order to trigger a confrontation clause protection for the defendant. There is simply no authority for it. So while Justice Thomas may have agreed in the ultimate outcome of Williams versus Illinois, he certainly did not agree in any respect for the reasons why he agreed with the 4 other justices in terms of the outcome, and I think that that's really critical. I mean, there are also, I think, some other very critical distinctions in Williams versus Illinois. The fact that it was a bench trial, not a jury trial, and the plurality opinion in that case very openly acknowledged that the dissent in that case, that their position would have much more force had it been a jury trial and not a bench trial. Also, the report in Williams in Illinois versus Illinois never actually made it into evidence. That's another important distinction. There are others, but for that reason, I think this hanging of the hat on Williams versus Illinois and the primary purpose test that comes out of that case is very much flawed, and it is not a test that this court should rely on, nor should this court respectfully follow. If the court doesn't have any other questions, I think I would actually reserve my time for rebuttal.
Okay, you may do that.
Excuse me. Good afternoon.
Good
Louis
afternoon.
Meislish on behalf of Plaintiff Appellee, people of the state of Michigan. May it please the court. Briefly, to address what counsel just said, we don't hang our hat on Williams versus Illinois. The Supreme Court in Clark versus Ohio unanimously observed that the primary purpose test governs. That was a unanimous opinion with 2 concurrences. There's no criminal investigation until a crime has been committed. When no crime has been committed, the primary purpose of a person making a statement cannot be to develop evidence for use at a later criminal trial. Notably, every case the defendant relies on involves a post-offense investigation and statements made therein, including faculty. When a person is not a testimonial witness for purpose of the Confrontation Clause, when a person is not a testimonial witness for purpose of the Confrontation Clause, that doesn't mean that they are immune or excluded from examination at trial. It only means that the prosecution need not produce them at trial based on the chance or the expectation the defense may want to examine them at trial. It only means, at least in Michigan, that if the defendant wants to examine them at trial, they subpoena them for trial, or they ask the prosecutor to compel their attendance at trial under MCL 767.40A. The defendant has not done so, at least not yet. Public safety agencies have a routine administrative obligation to determine whether their data master instrument can be placed in service and remain in service, or whether it must be removed from service. If it hasn't been inspected and checked out, they can't use it. They have an administrative obligation to know whether they can use an instrument in any drunk driving case that comes in, just like they have an obligation to know whether their dash cams are working, their body cams are working, whether their lockup facilities are operating and are safe, whether their fingerprint and booking systems are working accurately, irrespective of any crime that may have occurred or that will occur. That's in contrast with post-offense breath tests of arrested motorists. In those situations, they're clearly testimonial when an officer records the results of those tests, as was the case in Belvin. As records of regularly conducted activity, the administrative logs aren't analogous to investigators relating to the court what third parties told them about the circumstances of an offense. And that was the primary evil and the primary motivation for enactment of the Confrontation Clause. That's not my interpretation. That's what Crawford says. Marvin Geyer's statements, he's the manufacturer's representative, aren't a product of a post-offense criminal investigation. He's not a criminal investigator. In Nunley, this court observed that the most significant fact, I'll point out Nunley was a unanimous opinion, but the most significant fact was that unlike Melendez-Diaz, quote, it was not prepared the report was not prepared as a result of a criminal investigation or created after the commission of a crime. At that
Counsel, I
time,
just have a question, though.
yes,
And I totally appreciate your position, but doesn't this just result in more accuracy and accountability?
does the,
If you have to have the person available, doesn't it just create more accuracy and just and transparency and accountability?
well, not in every case is the breath, the bodily alcohol issue in dispute. But to answer your question, no, I don't think it does not, because it means that in every case, in the absence of a request from the defense, we have to produce them at trial if you adopt the defendant's position. Any witness that the defense may wish to examine, we just have to assume that they may wish to examine and produce them automatically. I don't think it's, what the statute says is unreasonable. If the defense wants to examine them and they're a non-testimonial witness, as we contend, then they ask us and then we do it, and we will. To adopt the defendant's position, this court would have to overrule Nunley.
Right.
Isn't the work and interpretation required for a data master log quite a bit more complex than the certificate of mailing that was at issue in Nunley? And isn't that something worth considering and even possibly a distinguishing factor between this case and Nunley?
I would say no, because in Melendez-Diaz, the court said, we do not hold, and it is not the case, that anyone whose testimony may be relevant in establishing the chain of custody, the authenticity of the sample, or accuracy of the testing device, must appear in person as part of the prosecution's case. As I was talking about with Crawford, if an offense has not been committed, the primary purpose cannot be to establish an out-of-court substitute, provide an out-of-court substitute for criminal trial testimony.
So is it a bright line rule? If the work is done before the crime is committed, it's non-testimonial?
I would say so. If you look at the sister state authority, which I think is consistent with Melendez-Diaz, with Crawford, with Davis versus Washington, with Melendez, with Boltman, it can't be testimonial if no crime has yet occurred. In the Kentucky Supreme Court point out that the fact that the records have an incidental use in evidence of the reliability of the machine during a particular time frame does not alter the fact that the records have a primary business purpose that would exist, i.e. to assure compliance with Kentucky statute, even in the absence of its litigation. So Marvin Geyer has to engage in this activity irrespective of any offense that may later occur. What he's doing is not analogous to the third party, the investigators relating what third-party witnesses told them about the circumstances of the offense, which is what Crawford discussed as the primary motivation behind the promulgation of the Confrontation Clause. If you adopt the defendant's argument, which will be inconsistent with every state court that has considered this issue, and all of the cases I cite on page 22 and 23 of my brief are post-Crawford, and I didn't count if they're more than half or slightly less than half, but many of the decisions are post-Melendez-Diaz. Unanimously hold that these are non-testimonial documents. And I think that's significant. I'd like to direct the court's attention to a case out of Nebraska, which was called Sorensen, that I cited in my brief. And in that case, they talked about a nurse in doing a blood draw of an arrested motorist for purposes of blood analysis for determining the blood alcohol content. And the court said, of course, that decision, that blood draw, and the nurse's certification that was done properly is testimonial. But it contrasted that with an earlier case from Nebraska called BRITT, B-R-I-T-T, where there was a certification on the simulator solution. There's a solution with a known quantity of alcohol that's put into the instrument to determine, well, it's supposed to be 0.08, and the instrument says it's 0.08, that's how you know it's accurate. And there's a certification that bottle, it has the correct control level. And the court said that's non-testimonial for the same reasons that I'm articulating now. It's before any offense that's been committed, and it's for an administrative purpose. And the sister states generally adopt this view that it's what is done before the offense in any offense, in calibrating the instrument and inspecting the instrument, is very attenuated from what is done when an arrested motorist is pulled over, arrested, and and there is an OWI investigation and an officer makes a statement regarding what the instrument said about their bodily alcohol content. It's not about whether we're targeting a specific individual or anything like that, like Williams talked about. We're talking about no offense at all has been committed. And if you look at Melendez-Diaz, Fackelman, Davis versus Washington, and Michigan versus Bryant, an offense had already been committed. In our case, it's even better facts for our side because no offense has been committed. In Clark, again, a unanimous opinion, they said it's irrelevant, it is irrelevant that obtaining the statements, and we're referring back to Michigan versus Bryant, where this person was bleeding out due to gunshot wounds, and the police were asking him about the circumstances of that, or in Davis versus Washington, which is the 911 call. The Clark court, which was about the disclosure of child abuse, said it mattered not that obtaining the statements or providing the statements had the natural tendency to provide evidence that might be later usable at trial, because the primary purpose was not to provide an out-of-court substitute for trial testimony. It was for some other purpose. Briefly turning to...
Counsel, can you,
Yes.
maybe you were going there, sorry if I interrupted, that business record exception. Can you address that and,
Sure.
and the question of the trustworthiness?
Sure. So there was the trustworthiness, there was, it's a very long rule, as I'm sure you noticed, but towards the bottom two-thirds, after much introduction, but it was a regular practice of that business activity to make the memorandum, et cetera, there's a few predicates that we have to establish, which I think we do. It says, unless the source of information or the method or circumstance of preparation indicate lack of trustworthiness. And that suggests that it is the defendant's the opponent, not always the defendant, the opponent of introduction of the records. It's their obligation to show they're not worthy of trustworthiness. The defense has not done that. Marvin Geyer, unlike people who, when he retired, took over, has not been implicated in any fraud or wrongdoing. At most, the defense can muster is that from a transcript that they appended in the district court, he acknowledged making a mistake in a prior case. I don't think that impacts his trustworthiness. It's their obligation to rebut. To go to the other prongs, doesn't the defendant has been challenging, for example, that the business record concerns an evaluative observation. The rule clearly covers conditions, opinions, or diagnoses. That was originally omitted from the Michigan rule when it was adopted, and then it was added in 1991 to be consistent with the federal rule.
Counsel, doesn't the trial judge just retain some discretion, though, to determine if the trial judge finds the trustworthiness standard not met in a particular evidentiary question, the trial judge retains discretion to say it's not met here. Isn't that right?
I'm not sure about they would retain discretion, but they can make that determination in certain cases. But in this case, we have, it is the defendant's obligation. The defendant did not demand an evidentiary hearing. They appended a transcript of Marvin Geyer's testimony from a prior case, and the district court simply said, these records are inadmissible. They violate the confrontation clause and the business records exception because Geyer doesn't work for the police department.
No, I'm not. I guess I'm not quibbling with whether the rationale was sufficient here. I just meant it sounds like we agree that the court does retain some discretion to determine trustworthiness. That's kind of a trial court's job, right?
Absolutely, and I will tell the court that there's this fraud that happened by the people who succeeded Marvin Geyer, and at the very least, with one of the two individuals has been convicted. I think the presumption, at very least with him, is easily rebutted by the defense. And at least I only speak for Oakland County. We are not introducing statements made by that person, not calling him to the stand. We're not introducing statements made to that person. The other contention the defense has is that Marvin Geyer doesn't work for the police department. Well, he worked for somebody who was contracted by the police department, and the rule doesn't have that distinction. It simply says the information, the record is, quote, made at or near the time by or from information transmitted by a person with knowledge. So if you adopt the defendant's argument, first of all, that would mean that even if we produce Marvin Geyer at trial, the statement, the logs would be inadmissible, which is inconsistent with Rule 803, which says the following are not excluded by the hearsay rule, even though the declarant is available as a witness. So if you side with the defense on issue 2, even if we produce them, the logs are inadmissible. But if you adopt that position, that means that any medical records where a patient makes a statement, which is pretty common in medical records, would be inadmissible under the business records exception, because unless the patient happens to work for the hospital. And nowadays, companies contract the record keeping of their electronic medical records, I don't know if all cases, but in many cases, to outside entities. So then even if you adopt the defendant's position, even the doctors who work for the hospital, since they don't work for the entity keeping the records, their statements would be inadmissible. That's simply inconsistent with the law.
If we conclude that the district court erred as a legal error or I guess it's a factual error, if it concludes that Geyer, no business record because Geyer wasn't really an employee of the state police for the reasons you've articulated, is that a reversal and therefore it is a business record and we send it back saying it has to be admitted? Or is that a reversal and we send it back to the district court and say, now check your boxes and everything else relating to a business record?
Well, I think the easiest route, is to deny leave, because I don't think the Court of Appeals clearly erred. At trial, we would have to lay the foundation that the actual logs that we appended in the trial court are the logs kept by the department. I think that's easy. But the court's determination, the district court's determination, was properly reversed because we established the prongs of business records. It's kept in the ordinary course of business. I'm talking too fast. And it's the regular practice of that business entity to make that entry, et cetera. Unless the opponent of the records, I'm going to quote exactly, unless the source of information or the method or circumstances of preparation indicate lack of trustworthiness. They haven't made that shown. I ask the court to deny leave. Thank you.
You had good reason to talk fast.
Thank you.
Thank you, counsel.
So to address some points made by my formidable opponent. First, to address Clark versus Ohio. This court in Fackelman, I think, very clearly stated that the primary purpose test put forth in that case was born out of the exigent circumstances context, and that the primary purpose test then only applies in exigent circumstances, just like in Davis. And it wouldn't apply in the normal circumstances where you didn't have exigent circumstances. Certainly in that case, right, you had, I believe it was a 3-year-old child who was disclosing sexual abuse, and you had, I believe it was school employees who were trying to get the child to safety and get information from the child. And so it was in the context of an emergency, and not exigent, an ongoing emergency, excuse me. And that's why the primary purpose test applied, just like why it applied in Davis. But in Fackelman, this court said that the primary purpose test isn't going to apply if there isn't an ongoing emergency. And that is why the analysis in Clark versus Ohio isn't going to apply in this context. Furthermore, to talk about Mr. Meislish's position that the defense can just subpoena the witness. Melendez-Diaz, the court in Melendez-Diaz made very clear that a defendant's ability to subpoena is not a substitute for a defendant's right to confront his accuser. So this position by the prosecution that, well, it's sort of like, who cares that the defendant has a confrontation clause, right? Because they can just issue a subpoena and that will make everything fine. I mean, the Melendez-Diaz court outright rejected that argument by the prosecution. And I'd like to turn to Justice Zara's question about Nunley and why, and I think it's really important to distinguish Nunley from the instant case. First, I think Justice Zara's question is very much on point. There are very important distinctions between Nunley and the instant case. One is this very highly scientific nature of the work that Geyer or someone like him does in this case, right? In Nunley, you just have this very routine, mundane task of mailing a certificate. But Mr. Geyer is engaged in scientific analysis, testing. It is subjective, not objective. He has to heat a solution to a very specific temperature of, I believe it's 34 degrees centigrade, so that it mimics the temperature of the human breath. If it's not heated to that exact temperature, it compromises the results of his analysis. He has to test for radio interference. There's these 10 steps that were detailed not only in the amicus briefs, but also in documents that were filed with the court. So it's not just this routine objective analysis, there is subjective analysis that is part of his work. That is a huge distinction between his work and the action taken in Nunley. Another distinction, and maybe this is me just saying the same thing a different way, is that Nunley, right, the certificate just showed proof that a mailing happened, right? This certification by Marvin Geyer, it's not just that a test was done, but it gets to the results of the test. And that is a huge distinction, right? It's not just I did something, but that the test results were acceptable. And that, I think, is also a huge distinction. And then,
But the rule seems to be, is it done in anticipation of litigation? And here, there's an administrative rule that requires this to be done. So isn't the fact that this is done for purposes of satisfying the administrative rule sufficient to put this within the cover of Nunley?
no, Justice Sarah, I would respectfully say no, and you just got me to a point where I was going to address that. Because in the Nunley decision, which I believe that you wrote, in discussing Melendez-Diaz, one important point that you brought out from Melendez-Diaz was that that court in part relied on the fact, right, that the certificates were made under circumstances that would lead an objective witness to reasonably believe that the statement would be available for use at a later trial. And in part, Your Honor noted that that was because the analysts were aware of the certificate's evidentiary purpose, since that purpose was printed on the certificates themselves. And that's at Nunley at page 701, citing Melendez-Diaz, 557 U.S. at 311. The same thing can be said in this case, right? I mean, this document says evidential breath testing accuracy log. It warns the person who enters information on this log, if you don't do this correctly, you will prevent this information from being admitted at trial. That puts this person on notice, do your job right, or this information isn't going to come in at court. So, Justice Sarah, that same point that you made in Nunley, that you observed from Melendez-Diaz, Marvin Geyer knows I better do my job right because this is for an evidentiary purpose, and that's why it's testimonial. That's why it triggers Mr. Fontenot's Confrontation Clause rights. It is different than the certificate of mailing that the guy, I don't remember his name from Nunley, at the Secretary of State would have no reason to expect, right, that it would come in at court. This puts Geyer on notice. This language puts Mr. Geyer on notice. I also want to note that one of the cases, and this was in my reply brief, that is cited by Mr. Meislich in his list of out-of-state court cases that support his position. Actually, one of the cases out of Alaska, I believe it's pronounced Abayo, A-B-Y-O, although it does land on the appellee's side, that case actually explicitly recognized that the certification of calibration reports are prepared in anticipation of criminal litigation. That language is specifically in that case. So I can't reconcile how that court can make that finding and not at the same time find that it triggers a defendant's Confrontation Clause rights. But I do think that when this court engages in intellectual honesty, you have to know that these logs are kept for purposes of criminal litigation. There is no other reason. Why else would you want a data master to be reliable? Why else would you want it to be calibrated? Because you want to prosecute drunk drivers. As it relates to the business record, respectfully, I don't think this court should come to that question because I think it is plain on its face that this is kept for the purposes of litigation, and that automatically takes the document out of 8036. But if the court isn't convinced by my powers of persuasion, obviously I think it doesn't fall under 8036 because it's kept for purposes of litigation, but I do think that it is also problematic, I mean, as conceded by the appellee, that Geiger is not an employee of the Michigan State Police. And I think that that raises an issue of you have an outside person coming within the entity and making entries into the document. And that raises issues of, I believe, hearsay within hearsay, and it raises issues of reliability because you have an outside person coming in and making entries into the document. But I don't even think that the court needs to get to that point because it is so clearly made for purposes of litigation. So I would ask this court to grant the application and reverse the Court of Appeals and find that the log is plainly testimonial. It is apparent on its face that it is for the purpose of evidence, and anyone, Mr. Geiger, who puts that certification in there does so with the expectation that it will be used at trial later.
Thank you, counsel. Thank you both. The case will be submitted. That concludes the case call.